I wanted to come here and discuss a few things that I've seen pop up or clients calling me, and that is the context of interventions or the subject of interventions in the context of dependency matters and dependency cases or foster care cases. I've had a few clients come to me who are caregivers, long-term caregivers or foster parents for children where the parents have since decided to exercise their right to choose an adoptive home for the child or to choose an agency to choose that home, but essentially to exercise their right to the care, custody, and control of their child in the form of consenting to an adoption for that child. So in that situation, a foster parent might come and come to me or seek counsel and say, well, what is it that I can do about that? Now, foster parents, as you know, are not parties to the dependency case. The new law that I discussed in October allows them to become parties for limited purposes, but it specifically excludes this scenario that I'm talking about, which falls under Chapter 63.082 Florida statute. So one of the things we would have to do is to brainstorm and figure out how we would become a party to that case, and we have been successful in making those arguments in court. And also, once we do that, then we would have to, if we pass that hurdle and the court allows us to become a party, then we can put on a case as an opposition if you are not in agreement with that. There are 8 factors that the court has to look at in determining if an intervention is in the best interest of the child. So it's kind of a 2-step process. First, the court has to determine that the person trying to intervene, the agency or the entity, the attorney, on behalf of the parents and the prospective adoptive parents to facilitate this adoption, if they filed the proper items. If they have filed the proper items, then the court must allow them to intervene in the case. There is not discretion for that. However, once the court has allowed them to intervene, the second part is that the court has to make a finding that it is in the best interest of the child to change the legal custody of the child from the state into the care of the entity or the agency for the purposes of adoption. So this is very, very complicated law. I think it's probably one of the most complicated when you're discussing about adoption and also dependency kind of combined. So it's not something, sometimes clients call me and the truth of the matter is I tell them, you might be able to even handle this yourself. This is what I would suggest, X, Y, Z. This is not something that somebody could handle themselves. Even an attorney who's just not versed in this area of law, I don't think would be able to jump in and handle this. So if you are facing a situation where you've been caring for a child long-term and the parents are exercising, one or both of the parents are exercising their right to elect to do a private adoption placement, and you maybe don't agree with that, I would expect that you would call my office so we can at least have a discussion to see if there is anything that can be done or what type of strategy and plan we could come up with to achieve the goals that you have for yourself and your family.